from supplementary list for hearing and order for 11 item 9, 2nd April 254 of 2020.
Concurrent finding against me, I am the original defendant, and both courts, the original suit for partition was decreed in favor of the original plaintiff respondent. Now, Your Lordship, only one confusion is there, I must disclose, that the appellate court mentioned that there has been a compromise which has been recorded between para internal page 10, Your Lordship may see para 8, where several appellants and the plaintiff, they have settled their dispute. Internal page 8, 10, para 8.
Yes, and he did it.
Before we proceed further, it would be pertinent to mention hearing that during the course of this appeal, following appellants, Nageshwar Mahato, Bhutta Mahato, Girdhari, so and so have compromised and settled the matter with respondent number 1, Srimati Chandrika Devi. And then next page, except appellant number 1 and 4 who are contesting the appeal, all the appellants have settled the matter with respondents. But here I must also disclose that it appears that all those persons who had compromised, their names are, they are the appellants also. This fact is not clear. Therefore, I was, may I pray only Monday, therefore only Monday. I'll call the otherwise I have the compromise petition. It is
Signed by
not.
all of them.
This is the compromise petition which was already filed. This is the appellate court has taken.
So they are the one. They are the one.
No.
The name has been
Your
written.
Lordship, it is not clear except appellant number 1 and 4 is or 1 to 4. So and so, all these things are not.
Appellant number 1 to 4.
There are several appellants. At least 21 appellants are there, but he has taken note, whatever names are there, those names are 1, 4, 5, 7.
The point is that if by virtue of this judgment, suppose in a suit, right, some of the parties they entered into some kind of compromise and the suit is not disposed of in terms of compromise, then any judgment will affect right of everybody, particularly in a partition suit. Isn't it?
Yes.
Then under such circumstances, merely because they have filed a partition suit and merely because it has been recorded, it has no bearing in the matter. You argue the case on merit. It is irrespective. Because once there is a partition suit and if any one of them has not, his share will be carved out.
Only problem was that the persons who had actually settled their dispute, whether they could have again filed an appeal against the same.
You see, it cannot be a partial settlement in a partition suit. It cannot be. Right? There is no decree as such.
No.
So?
It only mentioned that
that is why the court had no option but to proceed and decide the suit, the appeal. उससे कुछ फर्क नहीं पड़ता.
हाँ, वो कोर्ट मेंशन कर रहे हैं इस बात को कि ये लोग appellant लोग ये कर लिए हैं, लेकिन because the other parties who are there, 2 of them they are still contesting the matter on merit, and therefore the court has decided.
Court has to decide the suit. You just see so far as the trial court decree है
हाँ. ट्रायल कोर्ट डिक्री उसमें सेपरेटली फाइल हुआ, इसमें मेमो ऑफ अपील में नुकता नहीं फाइल हुआ.
अब देखिए इनका सब्स्टिट्यूशन भी हो गया.
हाँ.
रिस्पॉन्डेंट नंबर 1 चंद्रिका देवी का, जिनके साथ कॉम्प्रोमाइज हुआ.
हाँ, वो तो रेस्पोंडेंट थी, ओरिजिनल प्लेंटिफ.
हाँ उनके साथ तो वो भी हो गया. She was the original plaintiff.
हाँ
She has already expired. Substitution हो
ठीक
गया
ठीक
उनका.
हाँ
लखन में तो यही होंगे शायद original plaintiff. क्या करना है आपको?
Your Lordship, here is the matter of matter.
आगे तो
हम ये सिर्फ क्लियर करने के लिए कर रहे थे
That's
कि
right. But technically, I don't think that it will have any bearing.
क्योंकि if they themselves have compromised and then they are the persons who are challenging the same judgment which is passed.
Compromise, but it did not translate into anything.
हाँ, it did not.
It is meaningless. Unless a compromise is recorded in a decree, it is meaningless.
It was not disposed of.
तो फिर इसका कोई मतलब ही नहीं है. कोई इसका मायने मतलब नहीं. चंद्रिका देवी is the daughter and she is entitled to 1/8. इसमें क्या गड़बड़ है?
नहीं वो गड़बड़ otherwise नहीं है. Your Lordship may see the trial court judgment.
Yes.
Where the genealogical table is there, entire dispute is with regard to genealogy itself. First page itself, genealogy has been mentioned.
Yes.
Now, the undisputed part is that Jagannath Mahato had 4 sons. This is not in dispute.
Okay.
And the Chandrika Devi is claiming through this fourth son of Jagannath Mahato.
Who had two sons?
Yes, two wives. Two wives. It is said that he.
Hawa Devi and Mahwa.
No, but it is not clear that what was the name of the first wife. How he has mentioned that clarity is not there. But we are concerned with the second wife. The second wife is Mahwa Devi, and she had the plaintiff's claim is that this second wife of this Babulal. The Mahwa Devi was second wife of Babulal, who died leaving behind Budhan and this Chandrika. This was her claim. This is the only disputed portion.
Yes.
And whereas our claim is that there was no such, this Chandrika was not the daughter of Babulal. This is the whole dispute.
It's absolutely factual. इसमें क्या?
फैक्चुअल ये है. अब फैक्चुअल ये और एक बात है कि both the courts what they have done that when this particular aspect there was a suit in the year 1976 between the same parties with regard to another adoption deed, but in that genealogy was shown, and in that only Babu only this person's name, that means Budhan's name was mentioned and not Chandrika.
That is not binding
So,
in the case of
no,
adoption.
not binding, but that was the closest in point of time which could have shown that when the genealogy was in dispute, the court should have taken into consideration that exhibit, that document.
That was not genealogy by itself was not directly and substantially an issue to have a plea of res judicata that
No.
was there, so
No.
now it
Res-
cannot be there. You can't say that.
Res judicata was not there, but
Could be relevance.
the trial
So,
court,
please take it.
what the trial court has done, that it has said that entire onus was with me to prove that she was not the daughter of Babula. This is whereas our case is that no, it was for him to have, for the plaintiff to have proved this. One thing, or I must also point out one more thing. Our further case was that Your Lordship may see, Your Lordship is taking up appellate court, sir.
And in trial court, sir.
Trial court. Then in internal page 4. This was our case.
Just a moment. The learned counsel for the appellant has referred to the trial court's judgment and has submitted that the genealogy has been mentioned therein. The sum is that Jagannath Mehto had 4 sons is not in dispute. However, as per the genealogy filed by the plaintiff, the 4th son, namely Babulal, had 2 wives, namely Hava Devi and Mahava Devi. And the plaintiff was the daughter of the second wife, namely Mahava Devi. Plaintiff claimed that she was the daughter of the second wife of Babulal. He has also submitted that the first wife, the dependents are descendants of the first wife.
No, other branch of this.
ये जो फर्स्ट वाइफ के बच्चे ये भी डिपेंडेंट होंगे ना?
हाँ,
they are dependents.
सब लोग नहीं है,
लीलामान
सब बाकी जितना ब्रांच है सब डिपेंडेंट है.
branch of
other sons.
Okay, that's it. The learned counsel has submitted that as per the genealogy, the first wife had a son named Buddhan who died. Mrit likha hua hai?
हाँ,
Therefore, the dependents are the descendants of the other 3 sons of Jagannath.
हाँ,
Correct?
हाँ.
The learned counsel submitted the core dispute which arose in this case was that the dependent claimed that Chandrika Devi, that Chandrika was not the daughter of Babulal.
Yes.
And therefore the entire suit property belonged to the remaining 3 brothers, and plaintiff had no right title interest with respect to the property involved in the present case. He submits that in such circumstances, it was a case of the dependents that the partition suit at the instance of Chandrika was not maintained. Yeah?
And internal page 19 of the trial court judgment, last approximately 8 to 10 lines. यद्यपि, what is what?
Yes.
वाद पत्र में उल्लिखित वंश वृक्ष एवं वादिनी के अभिवचन में बाबूलाल की पुत्री हवा देवी के प्रश्न पर कुछ विरोधाभास परिलक्षित हुआ है, परंतु प्रतिवादी गण के मात्र नकारात्मक अभिवचन के आधार पर उसे अविश्वसनीय नहीं करार दिया जा सकता, क्योंकि प्रतिवादी गण अपने अभिवचन को स्थापित करने एवं सिद्ध करने में पूर्णतः असफल है, विफल है. प्रतिवादी के कथन पर स्वयं.
आगे बढ़िए.
हाँ, प्रतिवादी के कथन के समर्थन में ग्राम गिधैया का कोई भी व्यक्ति साक्षी के रूप में परीक्षित नहीं कराया गया है. ऐसी परिस्थिति में विशेष में प्रतिवादीगण का यह कहना कि वादिनी बाबूलाल महतो की पुत्री नहीं है अथवा प्रतिवादी द्वितीय पक्ष बाबूलाल महतो के पहले विवाह से उत्पन्न हवा देवी के वंशज नहीं है, वो सत्य एवं विश्वसनीय नहीं माना जा सकता है. मेरा दृढ़ मत है कि वादिनी बाबूलाल महतो की दूसरी पत्नी माहो महतवाइन के साथ उत्पन्न दूसरी संतान है तथा प्रथम संतान बुधम की मृत्यु हो चुकी है जो निसंतान मरा है. मेरे स्पष्ट मत है कि वादिनी को यह बात प्रस्तुत करने का वैध अधिकार है. वादिनी बाबूलाल की वैध संतान है, इसलिए बाबूलाल की जायज एवं कानूनी उत्तराधिकारी भी है. जायज एवं कानूनी उत्तराधिकारी होने के कारण वाद संपत्ति में वैध हित स्वत्व एवं अधिकार तथा वादिनी को वाद संपत्ति में विधि द्वारा निर्धारित अंश भी है. यद्यपि इस बिंदु पर कोई भी विवाद नहीं है कि विवादित संपत्ति 4 भाइयों क्रमशः फकीरचंद, तीतू, नूनी एवं बाबी और बाबूलाल महतो की है, एवं वादिनी ने यह कहा है कि बाबूलाल महतो की दूसरी पत्नी से उत्पन्न. प्लेटिव का एविडेंस पूरा कंसिडर हो. हाँ, considered
and the close relation has said supported the case of the
but that has to satisfy the test of section 50 of Evidence Act, where a person who sees the two relations behaving each other, then only his evidence would qualify the.
You see, वाहिनी संख्या 7 सुजीत कुमार यादव ने भी अन्य साक्षियों के कथन का समर्थन किया है और इस साक्षी के कथन से यह स्पष्ट होता है कि चंद्रिका बाबूलाल महतो की पुत्री है। यह साक्षी ग्राम विदैया की निवासी है। यह साक्षी यद्यपि चंद्रिका देवी की पुत्री का पति है, परंतु निकटतम संबंधी होने के कारण ये माना जाएगा कि यह साक्षी चंद्रिका देवी के
Your Lordship is reading
internal page 19.
One more thing was there.
और भी है, ऊपर भी है, काफी evidence है इसका।
One more thing was there, that it was when our case was that while marrying this Mahua Devi, Mahua Devi had brought one, this love beti word has been used, brought a small female child, which is the plaintiff. This is our case.
So she had, at the time of marriage, she had a child.
Yes. That means she was not the child of this Babula. जो है, I have to disclose. इसमें अब और टाइम लेते हैं, लेकिन अब नहीं वो नहीं, because parties were compromised, few parties were negotiating, therefore.
The Learned Council has also submitted that it was the specific case of the, it was also the case of the plaintiff, that at the time of marriage with Babulal, Mahua Devi already had a daughter, and therefore Chandrika Devi would not be said to be the daughter of Babulal.
एक पोस्ट स्टेटमेंट ही मेरा लिखा दिया जाए वो बेटर है। इंटरनल पेज 8 ऑफ द appellate court judgment, after 10 lines. It is further submitted by these defendants that the plaintiff Chandrika Mahto is the daughter of Nehru Mahto, who had come as Lag Beti in Chumna marriage by Babulal with Mahu Mahto after the death of Nehru. That means our
At page 8.
Page 8, after 10 lines from the top. It is further submitted by these defendants that the plaintiff Chandrika Mahto is the daughter of Nehru Mahto, who had come as Lag Beti in Chumna marriage by Babulal with Mahu Mahto after the death of Nehru. And my submission would be that despite recording that the main issue was whether the plaintiff was the daughter of Babulal Mahto or not, the appellate court and the trial court both have not tested the evidences in terms of section 50 of the evidence. This is my submission. And page 28 of the appellate court judgment, after discussing all the oral evidences, it directly page 28, para 17, it says that the court in the present case is concerned only with the vital issue that whether Chandrika was the daughter of Babulal or not.
Page number?
Page 28. But before finding it, also this particular question has been mentioned, but here is the para 17, page 28. The court in the present case is only concerned with the vital issue as to whether the Chandrika was the daughter of Babulal or not. May I kindly para 15 say it earlier. That would be better. I must. It is pertinent to mention here that from perusal of Exhibit B is the another judgment of the another title suit which I was referring of the 1976. Perusal of Exhibit B1, attempt to usurp the property of Babulal Mato has already been done by the Dolo Mato, who is predecessor uncle of applicant number 1. I could not get whether he was my predecessor or not. Uncle of applicant number 1 and also grand uncle of applicant number 4, and this full-fledged attempt has been made just to grab the land of Babulal. In this case of soft target was Budhan Mato, and the person claimed that he had adopted son, namely Gauri Shankar, which the adoption deed was declared null and void. It is a common trend to grab the property by denying the share of the ladies in the common property, be that it may so. It does not bother the court in the present case. The court in the present case is concerned only with the vital issue as to whether Chandrika was the daughter of Babulal or not. As aforesaid, the mode of proof in civil law is the preponderance of probability. In the present case, one thing is clear from the above discussions, and the plaintiff witnesses as well as the defendant witnesses have consistently deposed that Babu alias Babulal Mahato was married twice and lived in Hidaya, and disputed land was his property, and after the death of his former wife he had one daughter, Hawa Devi. Then he married Mahwa Devi, and from whom he had two children, Budhan Mato and Chandrika Devi. It is worth mentioning here that few appellants in the appeal have already compromised the matter with Chandrika Devi and accepted her claim. Since the matter was partially compromised between some parties, the court has to adjudicate the matter on merit. It is also pertinent to appreciate that a person being defendant, and again the claim of the plaintiff, has already accepted the contention of the plaintiff, then there cannot be any denial of the fact that Chandrika was the daughter of Babulal. Here at this point I will say that merely because some of the defendant have compromised, that would not make my case as bad. This is just before para 19 last 4 line. On the basis of discussions hearing before and appreciation of evidences in the light of attending circumstances, the point of determination in the present case is put to rest finally with the finding that Chandrika Devi is the daughter of Babulal Mato, and Chandrika is entitled to 1/8 share in the property through her father. This, and by this the appellate court has dismissed. So only two questions may kindly be taken note of. One is that both the courts have misconstrued or not misconstrued Exhibit B, which is a earlier judgment of the earlier title suit, where the genealogy was filed, where the name of Chandrika Devi was not shown, despite the fact that her brother's name was shown. So, and therefore there is misconstruction of Exhibit B, and the another is that the courts below have not tested the relationship of Chandrika Devi with Babulal in terms of section 50 of the Act. No witness has qualified to that extent. These are the only two questions which are. And one submission, last submission. The courts have wrongly casted onus upon the defendant in order to prove that Chandrika was not the daughter of Babulal. whereas the court should have, the onus was on the plaintiff to have proved this.
The learned counsel has submitted that 3 points arise for consideration in this case, although there are concurrent findings by both the courts. A. Both the courts have misconstrued Exhibit B, which was the judgment passed in title suit number.
Judgment is dated 6978 and 86 of 1976.
Title suit number 86
of 1976.
of 1976. Within bracket exhibit.
Exhibit B.
Exhibit B. Inasmuch as in the said case, in the genealogy, the name of Chandrika Devi was not mentioned, and in the present case, but the name of her brother Buddhan was mentioned. And the same case was relating to adoption by Buddha. Right? He submits that in the said suit, the adoption by Buddha was held to be null and void. Right?
उस केस में
the adoption by Buddha was held to be null and void. However, it is not in dispute that Chandrika was not a party in the earlier suit.
No, it has not.
Nor the genealogy was directly and substantially an issue in the same case. Adoption में तो नहीं होगा.
नहीं.
ठीक. Further point raised by the appellant is that the relationship of Chandrika Devi was to be seen in the light of Section 50 of the Indian Evidence Act, but the same has not been properly appreciated. He has further submitted that the court has wrongly cast onus upon the defendant to prove that Chandrika Devi was not the daughter of Babulal, although since Chandrika Devi claimed to be the daughter of Babulal, the onus was on her to prove the same. However, during the course of argument, it has also come to light that a specific stand was taken by the defendant before the learned first appellate court that Chandrika was daughter of Nehru Mehto, who had come as Lagbetta in Chumban marriage by Babulal with Mahu Mehta after death of Nehru Mehta.
This is our statement in WS itself.
That's why it is there, it is mentioned.
No, but your Lordship has mentioned that during appellate stage we have mentioned.
It has been submitted at the appellate stage. And on the basis of the same, the learned appellate court, recorded that the defendants were not in doubt that there were two wives. क्या लिखा है सामने?
कहाँ पर?
Page number 8. The defendants second party are no doubt.
अब
वो अलग है.
वो क्या बोलना चाह रहे हैं हम भी नहीं समझ.
मेरे को समझ ही नहीं आया. Anyway, it was there, right? After death of Nehru मैं बताऊँगा.
हाँ.
After hearing the learned counsel for the appellant, this court finds that Chandrika Devi, claiming to be the daughter of Babulal through his second wife Mahava Devi, had filed the suit seeking partition of property standing in the name of her grandfather Jagannath Mahto.
मतलब all these sons of Jagannath were recorded in record of
Claimed partition of ancestral property.
ancestral.
Ancestral property. However, it is not in dispute that the first wife had no child.
First wife, from first wife.
There was no child. There was no child.
ठीक.
And it is further not in dispute that Budhar Mehto was son of the second wife, who died issueless. And the plaintiff Chandrika Devi claims to be the daughter of Babulal and sister of Budhan.
Through what?
And full sister of Budhan. And full sister of Budhan. And filed a suit seeking partition. The defendants were the descendants of the other three brothers of Babulal. Correct?
And one sister of. This is the portion which I'm not clear, but it has come in evidence that there was one sister, Hawa Devi also.
Hawa Devi तो प्रथम पत्नी.
वही तो उसी के बारे में तो ट्रायल कोर्ट लिख रहे हैं कि इसमें कंफ्यूजन है इसमें.
That's right. That's right. अब आप बस जजमेंट सुनिए. बैठ जाइए. The learned trial court had bring the following issues for consideration. Appellate court के judgments में para 6. Both the parties led oral and documentary evidence.
Only one thing, I'm not disturbing.
Please.
वो एक नहीं हम दूसरा चीज बोल रहे हैं. बाकी जेनोलॉजी को डिस्प्यूट में जो नहीं है उसमें थोड़ा सा उसको नहीं ज़्यादा हाँ उसको ज़्यादा ये क्योंकि ना गलत स्टेटमेंट हम नहीं चाह रहे.
हम कुछ भी नहीं बोल रहे. हम खाली
क्योंकि यही डिस्प्यूटेड
हाँ
यही डिस्प्यूट है भी यही डिस्प्यूट. ठीक है वही.
इसके अलावा कुछ नहीं. I will not say anything more.
हाँ.
The learned counsel for the appellant has also indicated that essentially the dispute involved in the present case was as to whether the plaintiff was the daughter of Babula. हिंदी से ट्रांसलेट करने में टाइम लग जाता है. The issue number 4 and 6 were taken up together by the learned trial by paragraph 8 of the judgment. And while considering the same, the learned court recorded that the main point was as to whether the plaintiff was the daughter of Babula. It was the specific case of the plaintiff that the learned court recorded that as per the plaint, the plaintiff claimed that through first wife, Babulal had also a daughter namely Hawa Devi, but this was contradictory to the genealogy which was filed by the plaintiff. And Hawa Devi was shown as the first wife of Babulal. However, the court took into consideration that, however, as per the plaint, Babulal expired in 1958, who left behind his second wife Mahava Devi and a son Budhan Mehto and two daughters, namely Hava Devi and Chandrika Devi. However, the defendant completely denied the existence of Hava Devi, and they asserted that plaintiff was the daughter of Neeru Mehto and the mother of the plaintiff, namely Mahu Devi, was brought into the family by Babulal Mehto as his second wife through Chumman marriage, and at that point of time, at the time of marriage, the plaintiff was Lag Beti, ye likhenge. And thus the case of the defendant was that the plaintiff was, although the mother of the plaintiff was the second wife of Babulal, but the plaintiff was not born out of the wedlock of Babulal and his second wife. And at the time of marriage itself, her mother had brought the plaintiff. With this background, the learned first appellate court went on to examine as to whether the plaintiff is the daughter of Babulal and Mahu Mehta, or she was the daughter of Neeru Mehta and was brought in the family right at the time of marriage of her mother with Babulal. The learned court recorded that it was clear that the plaintiff lived with Babulal and Mahu Mehta as their daughter. The court also recorded that since the defendant claimed that plaintiff was not the daughter of Babulal and Mahu Mehta and was the daughter of a third person, namely Neeru Mehta. Therefore, this aspect of the matter was required to be proved by the defendant. But the defendant did not adduce any evidence in this aspect of the matter that the plaintiff was the daughter of Neeru Mehta. Thereafter, the learned trial court considered the evidences of the parties and considered the oral evidences of the parties and also inter alia considered the evidence of PW5 Ramdev Mehto, who had asserted that he knew Niro Mehto, who was son of Ganesh, and Niro Mehto had no daughter. And he had no daughter named Chandrika. The evidence of other witnesses were also considered by the learned trial court. The learned court has also considered the assertion of the argument of the counsel for the defendant in connection with the title suit number 86 of 1976, where also the genealogy was produced. And on the basis of which it was argued that in the said genealogy filed in the title suit of 1976, the name of Chandrika Devi as daughter of Babulal Mehto and Mahu Mehtai was not mentioned. However, the learned trial court was of the view that the genealogy produced in the title suit number 86 of 1976 cannot be relied upon. It is further not in dispute that the title suit number 86 of 1976 was suit relating to challenge of the deed of adoption, the challenge of adoption made by the brother of the plaintiff, made by Buddha Mehto, who had no son.
That detail is given in page 15 of appellate report.
I just come.
Page 15,
I'll come.
little portion.
Yes. Uh, This court also finds that the learned trial court, by considering the evidences on record, has also taken into consideration the provisions of Section 50 of the Evidence Act. And ultimately, after fully considering the materials on record, held that the plaintiff was the daughter of Babulal Mento. And therefore was entitled to inherit the property. The other issues were also decided in favor of the plaintiff. However, no argument in connection with other issues has been advanced by the learned counsel for the appellant. So far as the learned first appellate court is concerned, the appellate court recorded in paragraph 8 of the judgment that during the course of appeal, the number of appellants had entered into compromise / settlement with Chandrika Devi, who was respondent number 1 in the first appellate court, except appellant number 1 and 4, that is Sukhdev Mento and Chochu Mento, son of late V. Mento. Sukhdev Mento, son of late Jhabu Mento, appellate court statements. And consequently, the first appellate court had no option but to decide the case on merits. The first appellate court also considered the materials on record, including the judgment passed in title suit number 86 of 1976. ये exhibit 3 नहीं है, B है ना ये?
B.
पेज नंबर 12 में गलती से 3 है.
हाँ, 3 लिखा हुआ है लेकिन वो B. मेरा list of exhibit में page 10 में exhibit B.
And ultimately, the point of determination as framed by the first appellate court was as follows: forthcoming whether the respondent number 1 / plaintiff is the daughter of Babulal alias Babi Mento or not. In page 16 of the appellate court judgment. The first appellate court also considered the oral and documentary evidences placed on record and placed on record right from paragraph 12 of the trial court's judgment, of the appellate court's judgment, and recorded in paragraph 15 that from perusal of Exhibit B, an attempt was already made to usurp the property of Babulal Minto by Dulo Minto, who was the predecessor in interest of the appellant, number 1 and 4. And ultimately the adoption deed was declared to be an adoption deed by Buddhat Mehto, the full brother of Chandrika, was declared to be null and void. The learned court thereafter in paragraph 17 recorded that the vital issue in the case was as to whether Chandrika Devi was the daughter of Babulal or not. The learned court in paragraph 18 has recorded that the plaintiffs as well as defendants' witnesses have consistently deposed that Babu alias Babilal was married twice and lived in Gidya, and the disputed property was Ismail property, and after the death of his former wife, he had one son, one daughter, Hawa Devi. Then he married Mahava Devi from whom he had two children, Buddha Mehto and Chandrika Devi. This court finds that thereafter the first appellate court ultimately arrived at a conclusion that Chandrika Devi was the daughter of Babulal. After going through the judgments passed by both the courts, this court finds that both the courts have taken into consideration the materials on record. The defendants claimed it was not in dispute, it could not be disputed that Babulal had two wives, and the defendants claimed that the plaintiff was born through Nehru Mehto prior to marriage of Chandrika's mother with Babulal as his second wife. But apparently the defendants did not produce any evidence to prove that Chandrika Devi was the daughter of Nehru Mehto. Rather, the evidence placed on record revealed that Nehru Mehto had no daughter at all. This court is of the view that the court had rightly put the onus on the defendants to prove that that it was for the defendant to prove that Nehru Mehto was the father of Chandrika, which they miserably failed to prove. Once the marriage with the mother of Chandrika Devi was not in dispute, the onus was certainly upon the defendant to prove that Chandrika was not the daughter of Babulal. this court finds that the learned courts have passed the judgment keeping in mind Section 50 of the Evidence Act. So far as Exhibit B is concerned, this court is of the view that the same was the nullity in the state judgment relating to challenge of adoption was rightly not relied upon by the learned court as the fact as to whether Chandrika was daughter of Babulal or not was did not and could not fall for consideration in a case dealing with challenge to adoption by her full brother, namely namely this court finds that no question of law, much less any substantial question of law, is involved in this case. Accordingly, this appeal is dismissed.
Item 10, second appeal 83 of 2021.
Yes, appellant. Yes, please.
Lordship, the suit is dismissed. And reason is no valid cause of action. Plaintiff appellant claim ownership over the property on the basis of court sale deed, which is purchased by late father, appellant's father. And plaintiff appellants
No, I am
have
not able to get it. Are you the plaintiff or the defendant?
plaintiff.
Your suit has been dismissed by saying that there is no cause of action.
Yes.
Where is that finding? You filed a suit for
It is.
declaration of a title.
Yes. Title. In title suit judgment 139/2013 in page number 9, issue 5 and 6, in the light of the fact that the suit is held to be non-maintainable for the reason recorded above, even through the defendant have not laid any with respect to issue of the light of the issue 1, 2, 3 decided above issued accordingly.
Where is the judgment? I am not able to get the judgment. Right is the judgment. जहाँ मन होता है ना आप लोग जानते ही नहीं हैं इसको। आपका ट्रायल कोर्ट का जजमेंट मेमो अपील के साथ नहीं फाइल किया
प्लीज कभी मैं
मेमो अपील तो के साथ सिर्फ अपील कोर्ट का जजमेंट आपका ट्रायल कोर्ट का जजमेंट देयर इज अ ट्रायल कोर्ट जजमेंट सप्लीमेंट्री के साथ है।
और in civil appeal in 43/2019 in page number 20, whether the plaintiff have got valid cause of action for the present suit.
Where are the issues framed by the tribunal?
In page number 4, sorry, page number 9, 6/9, 6 page number 6.
Read the issues. Read the issues, please. Padi.
Issues 1 to 3 against the plaintiff.
These issues have been decided against you. And rest of the issues?
And rest issues
Issue number 7.
mainly no valid cause of action. Defendant are in position on the land and saying in the written statement that he is not in position and no concerned interest from the suit land. That's why main issue is no valid cause of action and suit was dismissed.
So every issue has been decided. It is not that every issue has not been decided. All the issues have been
Yes,
decided.
all health issues has been
Yes.
decided.
You read issue number 8 and 1 and 2. Internal page 8. Read it, please.
Whether the plaintiff are entitled to cast positions.
No, yeah. Page number 8. Number. The plaintiffs have not brought any evidence, oral or documentary, to prove that Pardon?
The plaintiff have not brought any evidence, either oral or documentary, to prove that the defendant had constructed any structure over the suit land. Suit land in entered by them through shaded mark as exhibit number 1 by B, or that their position had been in any way interfered with by the defendant who admitted the claim of the defendant over the land acquired by them through the shaded mark as exhibit 1 by B. As a manner, extent and kind of encroachment alleged has not been proved by any oral evidence of eye witnesses or even by the photograph. No photographic evidence of the alleged construction or documentary evidence of the mutation is as submitted in para 11 of the plan has been brought on record to show that the defendant had encroached on their property and dispossessed them.
You see, your claim was that defendants were making false claim in connection with plot number 1322, right? But you were seeking declaration of title over other properties, correct?
Yes.
And the defendants were also claiming title over other properties. But your cause of action was only in connection with plot number 1322, which was Schedule B of the property. Right? So the court says that with respect to Schedule B of the property, which you wanted some relief, there was no cause of action.
But fact is that, Lord say, defendant are in possession on all the land of the court salary.
We are not concerned with that. We are concerned with your suit. You may be in possession, not in possession. We are not concerned.
Now, today, I have filed a IAS number 70 2026 in the Anchal Adhikari reports in 144 520 2024. Several times I have filed 144 in the
So you may have a
esteem
fresh
court.
cause of action. If the court has dismissed your suit by saying that you do not have a cause of action. So if there is any subsequent proceeding under section 144, right, after the filing of the suit, you can have a fresh cause of action. Your right is not, you are not non-suited. The court says that there is no cause of action.
Lordship.
So you file a suit. Because now you have a cause of action, because there is a 144 proceeding in connection with the property which you claim.
And they are in possession.
You go and file a suit because you have a fresh cause of action. But so far as this case is concerned, what substantial question of law is to be?
Then may Lordship may kindly give the to file a fresh suit.
Liberty second
to file
appeal very good. Oh, you are there.
Liberty to
You
file
are the
a
master of all liberties.
Liberty to file a fresh
आपका क्या liberty हो सकता है?
in the
No.
eh,
144
now,
proceeding.
There is
आपको लग नहीं रहा कि आप कुछ ज्यादा ही मांग रहे हैं?
Lordship, there is a Anchal Adhikari reports and demarcation reports also is showing that they are in
इससे कुछ नहीं होगा.
Then
क्योंकि आपका जो कॉज ऑफ एक्शन है ना, वो आपके कॉज ऑफ एक्शन सूट 2015 का सूट है, कब का? 13 का. तो उस वक्त जो कॉज ऑफ एक्शन उससे होगा ना. बाद में आपके पास कॉज ऑफ एक्शन आया, आप अपना सूट फाइल करेंगे.
लिबर्टी में
लिबर्टी से लेते हैं. ये बहुत ही डिफिकल्ट चीज आपने मान लिया.
Plaintiff is very old persons.
वेरी ओल्ड पर्सन, उनको ओल्डर बना के उनको सब्स्टिट्यूशन मत फाइल कराइए. ठीक है ना?
And Lordship, he has right title interest over the suit property and the valid cause of action also.
उनको राइट एडवाइस दीजिए ना. आपको तो इतना बढ़िया एडवाइस देगी बिना मांगे. अगर आपके पास कोई फ्रेश कॉज ऑफ एक्शन है in connection with any of the property,
You may kindly allow to
I will not say.
file a liberty.
I will not say. I will not.
Fresh suit.
Liberty का कोई मतलब ही नहीं है. When there is no cause of action, the matter ends.
All this and defendant is not claiming over this land. No
Defendant
way.
is not claiming over Schedule B land at all. Simple. You wanted Schedule B land. Defendant is not claiming over Schedule B land.
So may kindly allow. liberty I can't.
ऐसे हम नहीं दे सकते। लिबर्टी तो आपको लॉ में इतना है कि हम इतना देंगे आप बंध जाइएगा। अगर हम आपको लिबर्टी में एक लाइन लिख देंगे तो आपके पास और सारी लिबर्टी फिर आप कैसे अवेल करिएगा? लिबर्टी तो भगवान ने आपको इतना दिया है कुछ कहने का नहीं। ठीक है, इसलिए उस लिबर्टी को लेके अपने आप को बांधिए मत। देखिए, for the learned counsel appearing on behalf of the applicant. This appeal has been filed against the judgment and decree dated 30/6/2021 and 19/7/2021 respectively by the learned Principal Judge Hazaribagh, dismissing civil appeal with bracket title bracket clause number 43 of 2019, affirming the judgment and decree dated 8/5/2019 and 22/5/2019 respectively, passed by learned civil judge with the bracket Union Division bracket clause number 4 Hazaribagh in title suit number 139 of 2013. The learned counsel for the appellant has submitted that the learned trial court had primarily dismissed the suit by holding that there is no valid cause of action. He has referred to IA number 70 of 2026, seeking to review additional evidence before this court, and has submitted that further cases have been instituted. Further case has been instituted by the plaintiff to the appellant before this court, being case number 520 of 2023. And there is an until Amin report dated 26/12/2024, which is an important piece of evidence. He submits that proceeding under section 144 CRPC was initiated and the case number was 520 of 2022.
And IA number 12328/2020.
It was initiated on 19/12/2023. What other IA?
IA number 12328.
He has also referred to IA number 12328 of 2025,
There is a valid cause of action.
seeking to adduce additional evidence by referring to
Last
case number 16 of 2027, passed under section 147 CRPC, by the Sub-Divisional Magistrate Hazaribagh to submit that
Last paragraph, page number 9. After hearing the irrevocable contentions of both the parties and after careful examination of all the relevant documents submitted by both the parties, it is evident that the matter involved between each party is
the learned counsel
disputes
has
of the time.
referred to the order dated 17/2/22 passed in aforesaid case number 16 of 2021 and has submitted that it has been observed that the case was dropped by observing that the aggrieved party may knock the door of civil court of competent jurisdiction for redressal of their grievances. The learned counsel has submitted that there is a valid cause of action and therefore the judgment passed by both the courts that there was no valid cause of action is perverse, and accordingly a substantial question of law be framed taking into account the aforesaid two petitions seeking additional days. यही आपका केस. After hearing the learned counsel for the appellant, this court finds that the suit was instituted as back as on as in the year 2013, showing the cause of action as 26/2013 and 5/12/2013, and the plaintiff claimed adjudication of right title over the Schedule A property, right title and possession over Schedule A property, and also made a prayer that khas possession be given to the plaintiff over Schedule B property, which was part and parcel of Schedule A property, and the defendant be directed not to put any illegal construction over Schedule B property. The learned trial court framed the following issues for consideration. And ultimately, the learned trial court recorded that there was no cause of action to file the suit, and decided issue number 1 and 2 against the appellant. The court referred to the discussions made with respect to issue number 7. The discussions under issue number 7 and 1 and 2 are quoted as under. A trial court का judgment statement. This court further finds that the learned first appellate court point for determination कहाँ लिखते हैं? upheld the judgment of the learned trial court.
In page number 5,
Sorry,
petition.
point number 1 कहाँ है point number determination?
B. Whether
Page number,
5.
where the
Right.
point of, at page number 14, as follows, para 9 में. By considering the point of determination number 1, the learned first appellate court also considered the provisions of section 34 of the Specific Relief Act and 35 of the Specific Relief Act and ultimately held that the suit was not maintainable. The findings of the first appellate court is as under page 24 of the appellate court's judgment. Page 25 is actually the court thereafter took up issue at point of determination number 2, which was dealing with Schedule B property, and ultimately held that the plaintiff failed to prove that the defendant encroached in the Schedule B of the plaintiff and constructed small house, and held that the plaintiff is not entitled for khas possession by evicting the defendant from Schedule B property. The findings are as under. Page number 29. While considering the point of determination number 3, the learning court recorded that there was no valid cause of action and ultimately upheld the judgment of the learning court. This court finds that both the courts have considered the materials on record and have given concurrent findings so far as the existence substantial evidence which is sought to be brought on record by filing interlocutory application are concerned, the same are relating to subsequent development, there can be no doubt that the cause of action with respect to a suit has to be decided as it existed on the date of filing of the suit. Any subsequent development giving rise to cause of action cannot be taken into consideration in the proceedings. इससे आपका काम बन जाएगा. There is no substantial question of law involved in this appeal, which is hereby dismissed. ये ट्रायल कोर्ट का जजमेंट है इस सेकंड वन हो जाएगा ना सर का काम.
From daily for judgment item 1 second to 94 of 2019 along with the
This judgment I could not complete. I could not complete it. थोड़ा सा correction रह गया. परसों के लिए. अपलोड भी सेम डे करना जरूरी है. थोड़ा सा corrections नहीं हो पाया है. And mom is in hospital. परसों के बाकी दोनों ऑर्डर्स
orders item 24 second appeal 34 of 2019.
34 ना? No substantial question of law dismissed.
Item 30 second appeal 72 of 2024.
No substantial question of law dismissed.
From supplementary list item 7 orders with effect second appeal file number C069 of 2025.
Yes.
Leadership, the survival effect is with regards to the changes to be made in the memo of appeal. Actually, in the last order, your Lordship had directed to be for the correction to be made in the decrees of the trial courts. So the corrections have been made, and the same have to be reflected in the memo of appeal. That will be done in a week.
That has been received back, but you have not removed your
Lordship, the changes will be made in a week.
ये के डिफेक्ट में लगा है. Filing is number 6069 of 20. The learning comes for the applicant. Praise for and is granted time till 19th of January to remove the surviving defects. If the defects are removed within time, post this case on 21st of January. The application.
Item 8 first appeal file number 8757 of 2025.
The defect is with regard to maintainability of the instrument first. I am the original defendant. The suit was filed by the plaintiff having the suit value of approximately 25 lakhs. My counterclaim was only for rupees 10,000. Suit decreed, counter claim rejected. So I filed two appeals. One against the decree of the plaintiff's suit and one against the rejection of my counterclaim. So this present appeal is with respect of rejection of my counterclaim. The office has pointed out the fact that since the value is of rupees 10,000, therefore this appeal will go to the district judge, which is, in addition, is not appropriate in view of the judicial pronouncement. So part of appeal will now be heard by this court, and the part of that will be.
There is no appeal, so far as the main appeal is concerned.
So far as the main appeal is concerned, there is a separate first appeal number 222 of 2025.
First appeal number?
222 of 2025.
It has been admitted?
No. And this is with respect of the rejection of counter.
Okay.
We should kindly see paragraph 25, 26 and 27. The Honorable Allahabad High Court relied on the full bench judgment of the Bombay High Courts. Here also the similar position was there. Para 26, I will refer. In the case of such and such, an issue arose to the forum to prefer appeal in the event suit is dismissed and counter claim is allowed, just reverse in my case. And the learned single judge of the Bombay High Court relied on the full bench judgment of the very court.
Which paragraph are you reading?
Paragraph 26, ladyship.
In case of?
In case of Tefelo Supra, an issue arose as to forum to prefer appeal in the event suit is dismissed and counter claim is allowed, and the learned single judge of Bombay High Court relied upon the full bench judgment of that very court in the case of such and such to hold that the forum of appeal would be determined on the basis of valuation of the suit and not the counter claim. In that case, the Bombay High Court has held that in the provisions contained under Order 20/19 CPC, as have come to be amended, the setup of a counter claim are treated at par and have been brought on the same platform with the equal status. Same treatment is to be given to the counter claim for the purpose of an appeal as is given to a decree of set-off. So the provision for appeal would be the same as applicable to the decree of the suit. And if no counter claim has been filed, the court therefore concluded if the legislative view is that the decree wherein the set-off is paid should go before same appellate forum to which it would have been subject in the normal course in absence of the claim for set-off. Then, so far as the counterclaim is concerned, the same treatment will have to be accorded to a decree passed in a suit where a counterclaim was preferred. As an extension of the same principle, the cross objection arising from the decree of set-off and or counterclaim will have to be given similar treatment in the matter of determination of the appellate forum. This same principle and analogy was made to apply with the cross objection. Thus, in view of the above exposition of law, the argument advanced by the learned counsel for the petitioner that since the cause of action is relating to the decree passed in counterclaim is resulting to the pleading in the counterclaim and the decree incorporates valuation of the counterclaim, it is this valuation would be relevant for determination of forum is rejected. The principal proceeding being suit proceeding and counterclaim being an added advantage given to the defendant to get his claim tried also against the plaintiff, but within the jurisdiction in which the suit has been instituted would mean that it is the valuation of the suit which will determine the forum of the appeal. And then the paragraph 31. Thus, for the purpose of payment of court fee, the valuation of the decreed counterclaim would be relevant. But for the purpose of jurisdiction, so as to select a forum, it is valuation of the suit which would be relevant. The district judge therefore rightly held that the appeal was maintainable. Because otherwise, yes, otherwise not maintainable because that was said that it will go to the High Court itself.
Where is the office ticket? This is office ticket number. office defect number? Which number? Which defect are you referring to?
So it's a objection is flag Y. The defect number is maintainability, serial number 7.
Thank you. Filing number FA8757 number. The learned counsel for the applicant has referred to the office defect by SR dated 24/11/2025 and has submitted that the office has pointed out that since the counterclaim was valued at rupees 10,000 and the present appeal is against rejection of counterclaim, therefore, on the point of pecuniary jurisdiction, the first appeal would not lie before this court. The learned counsel has then, if the learned counsel submits that such defect is not in accordance with law, he has submitted that the suit was valued at rupees
The suit value is 35,83,449 as per decree. I have got the another first appeal. Separate decrees were prepared. The suit value is
कहाँ से हम लोग देखेंगे इसको?
this appeal.
नहीं आप ऐसे आइए फाइल करिए भाई आप how do I find out?
The judgment it is written in the
Judgment में दिखाइए valuation. Where is the suit value in the judgment?
Let's come to
Which page?
page 12.
Page 12 of the judgment.
Yes. This is the suit value as per the plate. $28,89,879. On the top, it's for the jurisdiction and
The learned
queries.
counsel submits that from the perusal of the impugn judgment itself, it is apparent that the suit was valued at rupees 35,83,449. And in the same case, counterclaim was filed which was valued at rupees 10,000. Different decree has been prepared in connection with suit and counterclaim. He submits that against the judgment passed in the suit, first appeal number 222 of 25 has been filed. And so far as the counterclaim is concerned,
Rejection of
counterclaim is concerned, the present appeal has been filed. He submits that for the purposes of deciding the jurisdiction, the suit value is to be taken into consideration. It is बताइए reverse होगा counterclaim 10 लाख का suit value 5,000 का.
Yes, it will go to the civil judge junior division itself. This the law says. This Allahabad court. Suit is only for 5,000. Somebody raises a counterclaim for 10 lakh. It doesn't mean my court will change. It is always the suit value.
Counterclaim will not decide the
Yes, yes.
The learned counsel submits that the value of counterclaim will not decide the pecuniary jurisdiction and therefore the present appeal is continued. He has also submitted that otherwise also the appeal arising out of the suit as well as the appeal arising out of the counterclaim is required to be decided by the same court.
Because by common judgment, both has been decided.
As by the common judgment, both the suit as well as the counterclaim have been dismissed. he has relied upon the judgment passed by Honorable Allahabad High Court, reported in 2024, the bracket by file INRA 378, and has submitted that by referring to the judgment passed by Honorable Bombay High Court, the Honorable Allahabad High Court has ultimately held that the jurisdiction of the appellate court is to be decided on the basis of the valuation of the suit and not by the valuation of the counterclaim. However, so far as court fees is concerned, the court fees with respect to the counterclaim is to be paid in connection with appeal arising out of counterclaim. He has referred to paragraph 26 to 31 of the state judgment. इसको quote कर देंगे. After hearing the learned counsel for the appellant, and upon going through the aforesaid judgment passed by Honorable Allahabad High Court, this court finds no reason to take a different view. Accordingly, this appeal arising out of rejection of counterclaim, even if the counterclaim was valued at ₹10,000, is held to be maintainable before this court. The office defect in this connection is hereby ignored. Or going defect.
This is the only
The office is directed to place this appeal along with FA number 222 of 2025 on next page. इसको लिख दीजिएगा. This appeal is tagged with FA number 222 of 2025. इसको रख लेते हैं.
Yes.
From taking these orders, we defeat item 14, first appeal filing number 7843 of 2024.
Supplement. किसका फाइलिंग? Nobody appears on behalf of the appellant. On the last occasion when the case was taken up, also the appellant was absent. However, the records reveal that IA number 962 of 25 has been filed seeking to ignore certain reports. डिफेक्ट नंबर 25 बोल के तो कुछ है ही नहीं, मांगने हैं कहाँ है defect number? देखो defect. This court is not inclined to allow the integrity application. हमको तो नहीं दिख रहा है defect number 25. Accordingly, IA number 962 of 2025 is revised. The appellant is granted time till 6th of February to remove the surviving defects, to remove the defects pointed out by the office, failing which the subpoena shall stand dismissed without further reference to bench. Since the counsel for the appellant is absent, office is directed to forward a soft copy of this order for compliance. With the defects are removed in time, close this case on 10th of February and applicability.
Item 15 and 16 wrongly listed. Orders item 17, 1st April 21 or 2008.
In this matter, notices were issued upon respondent number 1. Respondent 1 subsection 2 and 3. So those two notices have returned undelivered. We are praying that we will write proper petition, appropriate petition for paper publication. The ladies should be directors for paper publication against the.
FA number 21 of 2008. The notice issued upon respondent number 1, 2 and 1, 3 has returned concern. The learned counsel for the appellant submits that he shall file an appropriate petition seeking substituted service of notice and pays for adjournment. Post on 20th January. 26.
Close one of the case FA number 233 of 18. But in spite of several requests to the State Council, they have filed a counter and IM laws. I am the beneficiary in that case, but a copy is not being served upon me in spite of not less than 15 requests made to them. And I have to file a reply to that counter. FA number 233 of 2018 laws.
FA number
233 of 2018. That's the council for the state is also here. I have requested not less than 15 times to their office. They have filed one IN and one.
IA number?
I have not been served that IA also.
IA का number तो होगा ना?
Just leave it.
कुछ नहीं पता.
है. एक second.